Pam Bondi came in with institutional authority and prosecutorial confidence. She had spent years in Florida's highest legal office. She knew how hearings worked. She knew how to project command in an adversarial setting. And she believed, based on entirely reasonable assumptions formed by years of watching these exchanges play out, that she controlled this room. Jasmine Crockett had a different set of assumptions and a different set of tools. And when the two collided, when Bondi attempted the kind of shutdown move that works against opponents who are performing legal knowledge rather than actually possessing it, what happened next did not go the way Bondi had planned. Not even close. If you are new here, subscribe right now and hit the like button, because we are about to give you every layer of this, not just the 60 seconds that made the clip, the full context, the full argument, the full legal significance of what actually happened in that room and why it matters beyond the politics. Start at the beginning. Not the hearing, further back than that. Pam Bondi's career is built on a particular kind of legal confidence. 2 terms as Florida Attorney General. A national profile built through high-visibility cases and political alignment with the most powerful figures in Republican politics. She brings to any formal setting the specific bearing of someone who has conducted press conferences on the steps of courthouses, who has announced major prosecutions with cameras rolling, who understands how authority projects in public legal spaces. That bearing is real. It is not performance in the shallow sense. It is the product of genuine experience in high-stakes legal and political environments. When she walked into that hearing room, she brought all of it with her. But there is a specific kind of legal confidence that comes from elected office, from press conferences, from political prosecutorial decisions made in environments where the audience is the public rather than a judge. And there is a different kind that comes from civil rights litigation, from standing in federal courtrooms arguing constitutional questions to judges who will not be impressed by bearing or by volume or by prosecutorial reputation, who want to know what the statute says and what the precedent holds, and whether the argument maps onto the doctrine with precision. One of those kinds of confidence is accustomed to winning rooms. The other is accustomed to winning arguments. They are not the same thing. And in a congressional hearing where the subject matter is specifically legal, where constitutional frameworks and statutory construction and documented governmental conduct are the substance of what is being examined, the difference between the two becomes visible under pressure. Jasmine Crockett spent years building the second kind. Her background in civil rights law was not theoretical. It was client work. Real people with real cases in real courtrooms where the quality of the legal argument determined actual outcomes in actual lives. Arguments in that environment have to be right. They have to survive examination by judges who will identify the weakness and exploit it if it exists. They have to hold up against opposing counsel who are paid to find the crack in the foundation. You cannot substitute political fluency for legal accuracy in that setting, because the setting does not reward fluency. It rewards correctness. And the years of operating in that environment build something that cannot be acquired any other way. A functional command of legal doctrine that is tested and verified and real, not approximated. She brought that into the hearing room. Bondi did not know the full depth of what she was walking into. The hearing had been convened around questions that were fundamentally legal in character, the proper scope of executive authority, the constitutional limits on the Attorney General's conduct in specific contexts, the statutory frameworks governing the Department of Justice's interaction with ongoing legal proceedings, the documented record of specific decisions and whether those decisions were consistent with the law as written or represented departures from it that required accountability. This was not a hearing about political philosophy or competing policy visions. This was a hearing about what the law said and whether the person at the witness table had operated within it. Bondi opened with the confidence her background produces naturally. She had clearly been briefed. She had answers prepared. She pushed back on the framing of the committee's concerns with the assurance of someone who expected that assurance to be sufficient, who expected the political dynamics of the room to operate in the familiar way where witness confidence and institutional standing allow you to absorb the questioning without ever being genuinely put on the defensive. The early exchanges went according to that script, more or less. Members asked questions. Bondi answered with a combination of factual responses and carefully worded deflections that acknowledged the surface of the concerns while avoiding the specific legal substance underneath them. It was effective. It is almost always effective. Most people asking questions in these settings do not have the specific legal preparation to push past a well-constructed deflection and get to the doctrine underneath it. Then, Crockett got her time. She did not start with temperature. She did not start with outrage or with a declaration of what she was about to prove. She started with a question. A specific, narrow, precise legal question about a specific provision of a specific statute that governed a specific category of conduct that was directly relevant to one of the hearing's central concerns. The question was simple on its surface and completely unambiguous in what it was testing. It was asking whether Bondi knew what the statute actually said, at the level of text, at the level of interpretation, at the level of documented application in actual legal proceedings. Bondi answered. The answer was not wrong exactly, but it was not precise. It was the kind of answer that someone gives when they know the general shape of a legal area without having gone into the specific provision being asked about. It was the answer of a lawyer who has engaged with this territory politically and administratively, rather than litigating it at the level of text and doctrine. Crockett heard the imprecision. She moved. She walked through the specific statutory language, not paraphrased, the actual language, the specific words, the specific construction of the provision, and the specific interpretive history that explained why the words meant what the plain reading suggested they meant. She cited the legislative history. She identified the specific committee reports and floor statements that established congressional intent. She connected the intent to the text, to the application, to the specific conduct at the center of the hearing's concerns. This was not performance. It was argument. Real argument, constructed in real time from a genuine command of the specific legal material. Bondi tried to redirect. The redirect was the move of an experienced legal official who recognizes that the terrain of the exchange has shifted in an unfavorable direction and needs to be moved. She shifted to a broader framing of the department's conduct, invoking prosecutorial discretion, citing institutional practice, invoking the traditional deference that has historically been extended to the Attorney General's office in matters of internal decision-making. It was a competent pivot, and it walked directly into Crockett's second line of preparation. Because prosecutorial discretion is a legal doctrine with a legal definition and a legal history and a set of documented constitutional and statutory limits that are specific, that are established, and that courts have enforced. It is not a blanket principle that immunizes any decision made by a prosecutor from legal scrutiny. It has a perimeter, and Crockett knew exactly where the perimeter was, which cases had drawn it, which factual circumstances brought conduct inside it, and which pushed it outside, and why the specific conduct that the hearing was examining fell outside the protection the doctrine actually provided. She said all of that, specifically, accurately, with the case citations attached. The room shifted in the way rooms shift when something substantive is happening. Not loudly. The shift was in attention, in posture, in the specific quality of silence that settles over a space where people are genuinely following an argument rather than waiting for their moment to speak. Committee members on both sides were tracking the exchange with a focus that is different from the performative focus of hearing room optics. They were following the substance. Bondi pushed back with more force this time. She had identified what she believed was an inconsistency in Crockett's application of the precedent, a tension between the principle Crockett was invoking and a specific line of cases that Bondi believed cut the other direction. It was a legitimate counter. It reflected genuine legal familiarity with the relevant area. And for one moment, it looked like she might have found the opening she needed. What happened next is the moment that legal commentators have been returning to repeatedly. Crockett did not dismiss the tension Bondi had identified. She acknowledged it as real. She explained why courts had struggled with exactly that tension, named the circuit split that had existed before the question was resolved at the appellate level, and then walked through the specific resolution, which court had addressed it definitively, what interpretive principle had governed the resolution, what the outcome had been, and why that outcome specifically undermined rather than supported the position Bondi was advancing. She named the cases. She described the reasoning. She explained the outcome with the fluency of someone who had read the opinions, not been briefed on their conclusions. The silence that followed was complete. It was not an uncomfortable silence waiting to be filled. It was the silence of an argument that has reached its conclusion. Not declared over. Not formally closed. Simply finished, in the way that genuine legal argument finishes when one side has answered the other's strongest point with something the other side cannot match at the level of doctrine. Bondi continued. Of course, she continued. You do not concede ground in a congressional hearing. You maintain your position, and you project the confidence that you entered with, and you let the institution's formality carry you to the end of your time. She did all of that, professionally, with the composure that her career has built. But the energy underneath the words was different from the energy that had animated her opening. The forward momentum was gone. What remained was competent, dignified, and thoroughly out of arguments. The aftermath was immediate among people qualified to assess it. Constitutional law scholars reviewed the specific arguments Crockett had advanced and assessed them on their legal merits. The assessments were consistent. The statutory analysis was accurate. The constitutional framing was sound. The precedents she cited were correctly described and correctly applied. The interpretive conclusions she drew were not just defensible, they represented the better supported reading of the relevant legal material. She had not been performing legal knowledge, she had demonstrated it, and the demonstration held up under expert scrutiny. Law faculty began incorporating the exchange into course materials, not as political content, but as a case study in how to construct a legal argument for a generalist audience without sacrificing accuracy. How to hold doctrinal complexity and communicative clarity in the same argument simultaneously. How to anticipate a sophisticated counterargument and prepare the response in advance so that when the counter arrives, you engage with its strongest form rather than its weakest. Government accountability organizations cited the specific precedents Crockett had surfaced in their ongoing advocacy, treating the hearing record as a contribution to the documented legal basis for the oversight work they were pursuing. Congressional staff noted specific points where her analysis had moved contested questions onto the official record in ways that would be useful for subsequent proceedings. For Bondi, the exchange represents a specific kind of reckoning. She came in as the institutional authority, the senior official, the former state attorney general, the current head of the nation's most powerful law enforcement agency. She brought genuine legal experience and genuine professional confidence. And she encountered a level of specific, documented, doctrinal preparation that those credentials, substantial as they are, did not equip her to match on the specific terrain that Crockett had chosen. That is not a statement about career accomplishment. It is a statement about the specific gap between legal experience acquired in political and administrative environments and legal knowledge built through adversarial courtroom practice at the level of doctrine. The gap is real. It is usually invisible because it is rarely tested by someone who has both the preparation and the composure to test it effectively. In that hearing room, it was tested, and the test produced a result that the record now contains permanently. For Crockett, the moment is the clearest demonstration yet of what her background produces when the conditions are right. The legal breakdown she delivered was not a peak performance moment that surprised even her. It was the output of a specific kind of preparation, applied to a specific subject matter, delivered in the specific environment where that preparation produces its most measurable results. She built it. She brought it. And when the moment arrived, it did exactly what genuine legal argument is designed to do. It settled the question. On the record. Permanently. In the language the law requires. The shutdown attempt backfired because the person it was aimed at had done the one thing that makes shutdown attempts fail every time. She had done the actual work. Hit the like button if this gave you the full picture you needed. Subscribe and turn on the bell. We are bringing you every moment that matters at the depth it deserves. See you in the next one.